when the COLA is equal to or less than 2.5%, pursuant to NJSA 48:4-45-.14. This is the ordinance that Lorraine discussed in her presentation.
I'll make the motion.
Second.
Comment? Roll call.
Perez?
Yes.
Siegel?
Yes.
Miliani?
Yes.
Lori?
Yes.
Tauriello?
Yes. Okay. Just briefly to update where we're at with respect to the Lopatcong Township Asphalt Plant litigation. As many of you know, some of you have recognized from the meetings, I know you were there, the current status of things, and I have sent several emails out to as many residents as I can, and will continue to do so, and will provide updates, because I have been receiving much interest, as you can imagine, in terms of the status of where we're at, where are we going, what are we currently doing, what additional things can be done, what's in the pipeline, who's doing what, and there's even some misinformation out there, or I think expectations as to what we're doing versus what private residents are doing. And I mean, we know because we authorize the action, but I don't know that it's entirely clear where we're at. Just to be clear, there were, and I don't know where to speak in terms of personal observation. I guess if I'm making a personal observation, I'll identify it as such. Otherwise, I'll be speaking in the capacity of just reporting as mayor in terms of what we've done. And I'll start with as mayor in terms of what we've done. Prior to the vote last Monday, where the application was approved by the Lopat Planning Board, we had authorized Jonathan Drill to file with the Appellate Division an appeal, which in simplest terms was challenging the Highlands Council, particularly Eileen Swan, who had issued I'm going to describe it as a curative letter, which in my opinion was devoid of all facts and reality, in terms of, to be as diplomatic as I can, where our argument, and I believe the correct argument, is that based upon the submission in Lopatcong's own documents in order to conform with the regional master plan, in essence said, we will not change our ordinances or amend our ordinances that can impact the Highlands Council without prior approval from the Highlands Council. They did not do that. They went ahead and they amended the ordinance without seeking Highlands Council approval. That is a significant procedural error, which we believe, and I'm confident correctly, makes the ordinance invalid. If the ordinance is invalid, that necessarily means that the asphalt plant is a non-permitted use, which means you are before the wrong board. You're not before the planning board now on a conforming application. You have to be before the Board of Adjustment, where, when you're before the Board of Adjustment, you have to consider off-site conditions and off-site impact as well as on-site impact. And when you're before the planning board, discussions of off-site activities are not really for the planning board's consideration, i.e. truck traffic on Route 22. It's a legitimate concern from a resident standpoint, but from a legal standpoint before the planning board, it's not really appropriate for discussion or consideration by the board. That's why we focused really intently on the Highlands Council, because that really changes the whole legal dynamic and posture of the application. because the Highlands Council, we believe, overstepped, well, let me be clear. Eileen Swan, who, I mean, we're talking about a state agency that normally would take 8 months to schedule a meeting. I mean, I'm exaggerating things, but in
For
12...
us, it was 2.5 years.
Right.
Go ahead.
Okay. So, I mean, and in 12 hours, we get a response basically saying, in like a My Cousin Vinny fashion, everything that guy says is BS. You know, just basically trying to undercut everything that John Drill said in a really rushed letter. I mean, it was the most disingenuous thing I've been practicing law since '92. I'm amazed at what I at that letter. Yeah. I mean, and it was just unbelievable. I mean, just really, and I think the amazing thing about that is, you know, the whole purpose of the Highlands Council is to protect our water supply, and you know, in their rush for political expediency, they literally threw, their whole mission and core purpose of what the Highlands Council stands for under the bus. I mean, it's really one of the most offensive things I've ever seen, done by a state agency. Really outrageous. And so with that said, we didn't have to wait for the planning board to make its decision. It was entirely appropriate to us to file with the appellate division. And some folks say, why are you in the appellate division? Why aren't you in Superior Court? Just to kind of expand on that a little bit. Because it has to do with a state agency action. So the appellate division is the original court of jurisdiction, and that's why we were there. And the notice of appeal and the case information was filed on that Monday. And to manage folks' expectations, traditionally, what will happen next will be a scheduling order will be issued. That will probably occur within the next 30 to 40 days. And in that scheduling order, it's going to set a briefing schedule. And that briefing schedule, traditionally, when I receive them from the appellate division, it's usually another 45 to 60 days in order for the parties to submit their briefs. And, and so goes the process. So things do not move slowly in litigation. And then, of course, the next question for many residents is, well, can they build the asphalt plant now while it's in litigation? And the answer is yes. They can, at their risk. That's right, Tom. And if they start to build and it turns out that it's overturned, that's a cost. I mean, they're stuck with that in terms of, so they can do so at their risk. Next question, can injunctive relief be sought to stay the development until it's ultimately decided? The answer is yes, injunctive relief can be sought. Has Greenwich Township sought injunctive relief, or will Greenwich Township be seeking injunctive relief? The answer is no. We will not be doing that. Are there other potential actions brewing out there? The answer is yes. Are those attorneys going to be seeking injunctive relief? I don't know. I know that it has been requested that they do so. I am not privy to those attorney-client communications for obvious reasons, so I don't know ultimately what's going to happen, but I do know that there are other attorneys and other interested parties who are considering taking action, which would be beyond what Greenwich has been doing in terms of its very limited legal issue. In that potential litigation, you would see issues, again, like the health, safety, and welfare in terms of failure to consider the groundwater, which we have to be clear about this. Whether you're on well or public water, it all comes from well here. So whether you get an aqua bill or you have a well in your backyard, it's all coming from the same place. So all of our water, the entirety of Greenwich Township drinking water, is in jeopardy here. It's not, well, my neighborhood, your neighborhood. We're all in it together on this, and there is a real significant threat to our drinking water supply, which is why we've done what we've done as a committee to protect the interest of Greenwich. On the other legal issues, which are legal issues for the Lopatcong residents and Greenwich residents who went to be heard, and for those of you who were there was absolutely, without question, a denial of due process rights where people were shut down and told you could not speak at all. Or it was, we'll start with everybody gets 3 minutes until John Drill gets up and then you get 2, or, whatever. It was like, the rules were ever changing depending upon the mood of the chairperson at the time. And those are things that courts don't take lightly, and, they're issues. But ultimately, how that impacts the ultimate goal of preventing the asphalt plant, I'm not going to comment on, but it's, that's a legal argument to make. And there are other substantive arguments that those folks can make that are beyond what we're doing in Greenwich. And I hope that provides some basis of a summary of where we're at, where we're going, what our next steps are, which really at this point is just for Mr. Drill to wait until he gets a scheduling order, and then he'll be preparing, his briefs and legal argument, and we'll see what happens. But it's not over yet. I mean, it's it's a step in the process. So I think we spent enough time on that.
Can I just add one more
Sure.
thing? While we were in the process of discussing this at Lopatcong, we were cognitive of the truck traffic going on Dumont Road. John did argue the Dumont Road truck traffic, and John was able to seek relief from traffic going on Dumont Road, and one of the many things. So at the very least, we were cognitive of trucks beyond what our normal truck traffic is, taking Dumont Road in any way, shape, or form to come through the Chase development. So that's off the table.
Right, a conditional approval was there not to use Dumont, Greenwich, or Main Street as part of their normal route. But if they are delivering locally, they can use it. So obviously, if they're going to pave someone's driveway who orders, I'm sure all the Greenwich residents will be lining up to purchase their asphalt from this plant. But hypothetically, if someone does that, they would be allowed to use it for that limited purpose.